Salute you all, and today's topic is about co-ownership in land. And as earlier I told you that co-ownership or co-ownership as a concept in land law, this is where it's a situation where two or more persons have interest in a particular piece of land. You get, or where two or more persons are entitled to a simultaneous enjoyment to a particular piece of land. That's what we mean by co-ownership in land law. And basically we have two categories of co-ownership. We have a joint tenancy and a tenancy in common. When you come for a joint tenancy, basically this is where two or more persons have interest in a particular piece of land, but with the right of survivorship and for unities. What do I mean by right of survivorship? And the joint tenancy, for it, they say that once one of the co-owners dies, his interests are invested into the surviving co-owners. Let me give an example. An example is, take for instance, we are 4 people that are owning a particular piece of a particular piece of land. Then one of us dies. You get, we remain 3. So the interest of this, the one that has died, will be invested, will be shared equally into the 3. And the joint tenants, there's no the things that, you know what, I'm the son of the deceased, I'm the daughter, I'm the wife, so I need the interest. It is not there. Automatically, once the co-owner dies, his interests are invested. His interests are invested into the surviving co-owners. The good case, there is a case of Hammersmith and Fulham LOBC versus Monk. Here they held that once property is transferred into individuals, into two or more individuals, basically that is a joint tenancy. And when I look at the right of survivorship, as I've explained, is whereby the rights of the interest of the deceased co-owner, they are invested into the surviving the surviving co-owners. And at common law, the right of survivorship was coexisting with a joint tenancy. So as we move further, however, things became, actually law looks on how it can make some situations simpler. In the due course, there came the right of severance. The right of severance, basically this came whereby it changed a joint tenancy into a tenancy in common. That was a right of severance. Basically here, under a joint tenancy, realize that each co-owner had equal shares. Had equal shares in that particular land, had equal shares, had equal time, had everything. There were no distinctive shares. But if it is a joint tenancy, it has the undivided shares, but with distinctive shares. For a tenancy in common. For it has these distinctive shares, but for a joint tenancy, for it doesn't have. If at all, let me give an example. If at all you are owning a piece of land and a joint tenancy, that piece of land you can utilize it the way you want, and you can utilize it in whichever corner that you want. You get? So you own that particular piece of land. You can say that, let me grow maize. You can also grow it, all of it. You can also grow maize on the whole piece of land. So long as you have sat as the co-owners and agreed, they cannot sue you for trespass. You can do anything and enjoy it tenants. Your rights are are all over the land. Then that they bought a right of severance basically this was a right whereby a joint tenancy was turned into a tenancy in common. You get it? But however, the right of severance, it only lived so long as you didn't die. You cannot die after you ask for the right of severance. You could only ask for it so long as you are still alive and you are still in that co-ownership. So have that, note that You get? And a joint tenancy was always severed into certain categories or into certain ways, either writing to the joint tenancies, acts of a third party, or acquisition of another estate into the what? Into the land. You get? Those are the three ways how a right of severance could be acquired in a joint what? Tenancy. Writing to the joint tenancy, acts of a third party, or acquisition of another estate into that particular what? Estate. You get? That's where a right of severance could be what? Could be attained. Then, when we see the case of William versus Hensman, the case of Williams versus Hensman realized that a joint tenancy of a personal estate could be severed by an act of any of the persons interested in operating upon his own what? Share, mutual agreement or course of dealing sufficient to intimidate and the interest of the all were mutually treated as being tenants in what? In common. For right of severance, you could ask for your distinctive what? Share through writing. But if at all the co-owners refused, you couldn't what? Claim. But if they accepted under mutual agreement, they say that, you know what, let's give the other one his distinctive what? Share. Then that is a right of what? Severance. Then when you go further, or when we see further, we have said that we are on right of survivorship. And when you go further, we realize that we have 4 unities under a joint tenancy. And one of the unities, we have the unit of possession. The unit of possession, these are the unities that make up a co-ownership or a tenancy, or a joint tenancy. The unit of possession basically here says that each co-owner possessed land equally. You get? He could possess land equally. He was entitled to the full possession of that particular land without any limitations from his co-owners. You get? That is the unit of what? Possession. When you read the case of Bull versus Bull, that case held that co-owners are entitled to undivided possession, you get, of the co-owner land to the exclusion of others. What do they mean by undivided possession? We could own land, but nobody had a particular share on that land. We all owned that land equally, you get. So that is the unit of possession. We have the unit of interest. The unit of interest, basically, we also had, the unit of interest deals in whereby the interest of each joint tenor must be to the extent that the nature and the duration and the unit of interest, basically, we all had equal interest in the land. We all had equal, in every interest, even if we could lease that land, we all had the interest on that lease land, on that land that is leased. You get? And some of the consequences of the unit of what? The unit of interest is that the unit of interest, basically, the whole collection of rent, in case there were the profits attained, the profits, the rent were all what? Divided equally. However much, even if you are the one who brought someone to be on that land on the issues of rent, the money could be divided what? Equally. Rent, the profits attained, any business that was done on land, so long as it brings profits, the profits were supposed to be divided what? Equally. Then when you go to they also say that it could be that the whole estate was equally what? Was equally owned by the co-owners. You get? And under joint tenancy, between those interests and the duration are similar, must be similar. Give the tenant's fee, the tenants in fee simple at the tenant and fee tail, they must be what? Similar. That topic refer to the topic of the doctrine of what? Tenure and estates. It highlights that essence there, the doctrine of tenure and estates. And basically there you have to bear in mind that here, the unit of interest, everything must be, any interest that was gained on land or any interest that was land was divided between the two between the co-owners. And and also we have the unit of title. The unit of title, basically here what you have to bear in mind that if it is that land title, it must bear all our names as the co-owners. If that title has only one name of a co-owner, then that's not a co-ownership, or it is not a joint tenancy. But for a joint tenancy, the land title of that particular land must consist all our names. That is to deal with the unit of title. We have the unit of time. The unit of time, basically, the interest of each tenant must vest at the same time. What do they mean by interest? If we are purchasing that land, we must have purchased it at the same time. That is the unit of time. If it is to share the profits, we must share them at the same time. There's nothing like, let this one wait, let the other one come first. That is the unit of what? The unit of time. That is to deal with what? A joint tenancy. Then when we go to a tenancy in common, for a tenancy in common, it came after equity. You get it? It came after equity. Remember, there was under common law, any land that was owned by two or more persons, it was regarded as a joint what? Tenancy. But equity came in and said, no, not everything must be what? Must be a joint tenancy. There must be a tenancy in common. And the good definition of a tenancy in common is that this is ownership of undivided but distinctive shares. Hope you get the difference. Undivided but distinctive shares in a co-owned property or land. The land is undivided, but we have distinctive shares. What do I mean by distinctive shares? Distinctive shares may mean that, you know what? We haven't divided, but we all know that the other one, if it is farming, the other one digs from the other side, may dig from this side. We all have those portions, but the land is not divided, and you cannot sue me for what? For trespass. You get? Basically, those distinct shares, they are known by you, but they are not portrayed what? Expressly. You get? Then when you go, that was at equity. Equity is the one that brought what? A tenancy in common. And also, a tenancy in common, for the only thing there is no right of what? Survivorship. But all the other unities what? Exist. But the right of survivorship, it is not there under tenancy in what? In common. That must be placed in what? In mind. And also when you read the case of Robertson versus Fraser, this case held that the presence of words that prove division of property, thus the said property, will be held in a tenancy in common rather than a joint tenancy to the existence of words of what? Severe res. Read that case of Robertson versus Fraser to get a good what? Explanation of the preamble. Then when you go that since equity is the one that made a joint tenancy at a certain scenario to be regarded as a tenancy in common, equity came out with different scenarios whereby a joint tenancy was presumed to be a tenancy in what? In common. Because equity is all about fairness. So they brought fairness in this what? In this matter. And one of it that I can say that equity brought, they brought a purchase of money provided in unequal what? Purchase money provided in unequal shares. What do I mean? If we are to buy a particular piece of land and the land is 4 million, but one of the co-owners brings 2, another one brings 3, which means that is a tenancy in common because we purchased the land with unequal what? Shares. You get? So where there is purchase made with unequal shares, that is automatically a tenancy in common, but not a joint tenancy. Everyone has a distinctive share because you can't say that it's a joint tenancy. So what if the other one that purchased with the highest amount died? You see that it will be unfair for this one to take the what? The whole interest of the other deceased person. So they said that it is what? A tenancy in common. Tenancy in common, there is the interest of your land can be taken by your people. Rather, they are not invested in the surviving co-owners. When you read the case of Robinson versus Preston, that case is on the purchase money provided in unequal shares, where court held that the contribution to the purchase price was unequal proportions property owned under tenants in common. Where there is the purchase price was of equal portion, parties and own it under joint tenants. Where there is equal, but once there is no equal, then it is a tenants a tenants in common. Read the case of Robinson versus Preston. Then when you go further, we have the loan or a mortgage. A loan and a mortgage, it is unfair to say that it is a joint tenants. You get? But however, the mortgagees, the mortgagees, once you mortgage a particular piece of land to more than two mortgagees or one mortgagee, those people, they have a tenancy in common. They have distinctive shares, because everyone has a particular sum of money that I got from him or her, me as a mortgagor. You get it? So it is unfair to call it a tenancy in a joint tenancy, whereas it is called a tenancy in common. You get it? Then we have partnership assets. What do I mean by partnership assets? Partnership assets and property acquired for business purposes. Any property acquired for business purposes and it brings profits, it is regarded as a tenancy in common, not a joint tenancy. You get? When you read section 23 clause 3 of the Partnership Act, it portrays that element that I'm talking about, whereby it speculates that where co-owners of an estate or interest in land which is not a partnership property are partners to the profits made by the use of land or estate. The land or estate purchased belongs to them. In the absence of an agreement contrary or as partners as the co-owners are respective, it will be presumed to be a tenancy in common. Everyone is awarded his profits, whether he's dead or alive. The profits go to the family or any other he would wish to be utilized. So that is a partnership assets and property acquired for business purposes. When also you read the case of Lake versus Craddock, here realize that there were five people, they equally contribute to the purchase of land to be sold in small blocks for profits. It was fine, it was the same amount, but it was to be sold in small blocks to get profits. Then one of them abandoned the project and died after. You get? So the question was whether it was a joint tenancy or a tenancy in common. But however, the court held that a tenancy in common was available because payment of the money created a trust undertaking profit or loss as nature of the of the merchandise. You get? The essence of the investment was to make profits. That's why it was regarded as a tenancy in common. You get? Hope we are moving on clear. If we are not clear, please put in the comment section whereby you feel that you haven't understood. But we can move forward. That is to deal with the partnership assets and properties acquired for business purposes. Then you also have contracts and executory trusts. What do I mean by contracts? A contract is expressly vivid. You agree on the terms and the conditions. Where there is a contract or there is an executory trust, obviously that calls that it is a tenancy in common. There is a beneficiary, you understand? And in the trust there is a beneficiary. Then under a contract, realize that there is the terms and conditions that you have agreed upon. You get? That is to deal with contracts and executory trusts. Then that's some of the essence of some of the things that we can use, or what equity looks at, where equity looks at a joint tenancy as a tenancy in common. Then when you read the RTA, which is the Registrations of Titles Act, section 56, also speculates on what is regarded as a joint tenancy of land, or when is a joint tenancy deemed to be a joint tenancy. Then we shall move forward to the topic of rights of the co-owners. You get? When you go to the rights of co-owners, we have a right of occupation rent. What do I mean by occupation rent? Basically, each person that lives on that land must. What do I mean is that must not be asked rent. That is a right. You are exempted from occupation. Even if you occupied the whole land as a co-owner, you cannot give rent. You get. Read the case of Johnny's versus Johnny's. Court held that even if a co-owner occupies the whole land, other co-owners are not entitled to ask rent from him or her. That is to deal with occupation rent. You get. And also, it is also right that co-owners cannot evict others from the land or out of what? Trespass. You get. That is to deal with what? With occupation rent. Then we have a right for compensation for improvements or repairs on the co-owned land. The general rule under common law, they say that a co-owner cannot be compensated for improvements and repairs made on that land. What do I mean by improvements? If you put some of the things on the land, what on the land that we are co-owned, and you make it on an individual basis. At a common law, once a co-owner improves land, he does that on his own what? On his own frolic. He cannot ask. But at equity, upon the termination of co-ownership by the seller and or the improvements done on the when actually, let me give an example, on partition or on ending so when the co-ownership or the co-ownership ends, that person is entitled to what? Is entitled to compensation for improvements at equity once they want to end what? The co-ownership, either by sale or by partitioning, is awarded what? Compensation. That is at equity. But at common law, the general rule is however improvements you make, they cannot compensate you in the due course of the co-ownership. Then you also have a right liability to account for profits. What do I mean by liability to account for profits? Here comes in the way that a co-owner, a certain sentence, they say that a co-owner is not accountable for profits received from co-owned what? Property. Because all co-owners have a right to enjoy the possession of the whole what? Property. But however, in equity, the other one was at common law. But however, in equity, a co-owner is accountable for profits received from a third party. A third party, it may be a leasee, someone that leases the particular land. He pays a certain amount of money. That is accountable. Where a third party is leased land by a co-owner, the rent is shared among the co-owners. You get? That is the case of, relate to the case of Henderson versus Eason. Henderson versus Eason of 1851, where the action of account of profits can stand where the party Iggy got more share than the others in terms of the surplus that was obtained from a third party, basically. So basically, those are some of the rights of the co-owners on a particular piece of what? Particular piece of land. Then when we go further, we have what? We go to the termination. Termination of a what? Of a co-ownership. What do I mean by termination? Termination of a co-ownership, basically here, this is where termination of a co-ownership comes to an end. You get? But remember, the right procedure is the right of survivorship. Survivorship is the one that turns a joint tenancy to a tenancy in common. For a co-ownership to be seized, a joint tenancy must first be turned to a tenancy in common. Then a tenancy in common is the one that is ended. You get? A joint tenancy cannot be seized automatically, but it first turns to a tenancy in common, then it comes to what? An end. So we are going to see. One of it is partitioning. We have heard of partitioning of East Africa, of Africa, then partitioning. Partitioning here basically deals in the act of dividing or separation of what? Of the creation of boundaries on a particular piece of land. Partition, basically, everyone is given his share. That is partitioning. And we have some of the elements of partition, some of the categories of partitioning. We have voluntary partitioning. This is where the co-owners sit on table and they agree. We have compulsory partitioning. This is done even if the others are not what? Are not agreeing. It is compulsory. Then we have, which is sale at the end. Sale is also a different or an independent what? An independent element of termination. You get sale. Basically, you sell the property and you share the amount. But remember, this is a question that you have to know that the question may ask you if if you have sold a particular property that was co-owned, when does the co-ownership end? That is a question put across to you. But what you have to know that a tenancy or a co-ownership ends the moment you share that money that you have got out of the property. Once you haven't shared the money, the tenancy or the co-ownership still exists. It ceases immediately to share that particular amount of what? Of money. Then sale comes after. Then we have the union in a sole tenant. Union in a sole tenant, this is also an independent element for termination of what? Of co-ownership or a tenancy in common. Union, basically, this is where all the interests are invested into one what? Co-owner. Once all the interests are invested into one co-owner, this automatically ceases or terminates the what? The co-ownership. That is union in one sole what? Tenant. And basically here it can be divided, it can be categorized in the union where tenancy are determined by the whole what? Land and becomes invested in one single beneficiary who becomes the owner and the overseer. You get? So here becomes the sole tenant is like a right of survival. He has taken, basically there is no any co-ownership then. Then we have in the release and also the union in a sole tenant. Release, basically it was a common law whereby they say that since a joint tenant owned the whole land of the whole piece of land, he or she could only transfer his rights to another joint tenancy by deed or release which operated with a distinguished right. You understand? So it was done through release and sale, which I talked it before. So those are some of the categories where a joint tenancy or a co-ownership can be what? Terminated or comes to what? An end. You get? And when you look at, so that is what they call co-ownership of land. Yeah, basically, where you feel that you haven't understood properly, please, any area about this particular topic, put it in the comment section. And here, what you have to bear in mind is that a joint tenancy and the tenancy in common, these are things that you must be knowing on your fingertips. What do they mean by a joint tenancy? What do they mean by tenancy in common? So basically, note that, put that in what? In mind. So thank you for listening. Basically, that was the essence.